last case, which is Oquendo versus United Property.
May it please the court, Your Honors, my name is Eric Trevetti. I represent the plaintiff, Samuel Oquendo. I request 5 minutes for rebuttal.
All right.
This is a case where Mr. Oquendo is appealing a summary judgment that was entered against him, final judgment that came out afterwards. Essentially, Mr. Oquendo brought suit against his insurance carrier when a claim was denied. When I say insurance carrier, I mean his homeowner's insurance carrier. At the motion for summary judgment, the insurance carrier argued that Mr. Oquendo testified at his deposition in such a way that established one of the exclusionary clauses in the policy. The errors that we bring before the court today are threefold. First, we point to the fact that there's a fundamental error with the final judgment. Specifically, it's predicated upon an affirmative defense that was never pled. The second error is the policy language, as it was applied by the trial court, was improperly applied. Specifically, we contend that the policy, and this is page 14 and 15 of the initial brief, we contend that the policy language specifically starts out applying or creating an exclusion for what we would call long-term water seepage, but then goes on to create or restore coverage unless there is yet a third prong added to this. And the third prong would be found in the area which is also called Section 1 exclusions. And this is quoted out for you on page 15 of the initial brief. And so we argue that the specific language in the brief, the specific language in the policy doesn't in fact render any kind of an exclusion for long-term water seepage unless there is also, for example, a loss that was caused directly or indirectly by flood, surface water, waves, tidal water, overflow of a body of water, and so on.
Isn't the key issue here, though, whether it was unknown to the insured or not?
Yes, it is. And I'm glad you brought me to that because that is the third point. And so the third point is there is a genuine issue of material fact as to that. And this is, in my 10 years of practicing law, probably one of the more difficult transcripts that I've had to read. Specifically, here's really what I'd like to point the court to. And this is, I'm going to refer to the appendix to the brief so that everybody has it. This would be page 10 of the deposition transcript in the appendix. On page 10, this is probably within the first 20 minutes of the deposition, Mr. Oquendo specifically says, "So I decided to get a certified company to put a camera through the plumbing to see what the problems were." This is the first time, and this is important because it frames the context for the next 2 or 3 hours of testimony that Mr. Oquendo gives.
Well, and I don't mean to interrupt you.
Of course.
Because he's going to spend time saying, I'm not a plumber, I don't know anything about these kind of things, I don't have any expertise in this area, I didn't really know what the cause of this was until I brought a plumber out. Isn't that the essence of what he said? But here's what I think.
Correct.
Here's what I think the point is. The reason why insurance companies put this language in there as known or unknown is because they don't want somebody to sit there and say, the roof's kind of wet, but I'll get to it next year or the year after that or the year after that. And meanwhile, mold spreads, rot spreads, all of this, and they say, well, I don't really know what the cause of it was, but I knew it was moist up there. Insurance companies want them to deal with it now so that damage doesn't get worse. Isn't that really the concept here?
That is exactly, I think, why insurance companies want that kind of coverage or those kinds of exclusions. I think in this case, we have a record that doesn't establish any kind of mold or any type of damages which would...
But they saw water for 3 years.
Well, let's actually talk about that. And I think the easiest way to deal with this is if I go to the answer brief. Give me just a moment, Your Honor. On page 2 of the answer brief, the appellee sets out what I would contend is probably the most troublesome testimony for my side of the case, for the insured side of the case. Specifically, we have the first quote where they say, and they're citing to volume 3, 417 and 418. There was a bad smell coming from the sink. A bad smell, to me, is not indicative of anything. We We contend that this is not the first time that the homeowner should have known anything was wrong with the property. He moves on to, the appellee moves on to cite that the toilet wasn't flushing right and actually never really flushed right. In that same line of testimony, the appellee points to the fact that water had to be added to the toilet from time to time to get it to flush properly. None of this is indicative of a leak or what otherwise...
What about the water seeping on the floor that the wife had to clean up almost daily?
Well, I'm glad you brought me to that. Specifically, we have Mr. Okendo speaking about facts that have been relayed to him by another person who's not a party to this action. So I would argue that it's not adequate summary judgment evidence. It doesn't fall under hearsay exception. And since we know the deposition of the wife was, I don't know if the deposition of the wife was taken, but we know that there's no record from the deposition of the wife that's in the record where she relays her personal observations. So the problem with that testimony, specifically whether or not water was spilled, reached the floor, and was cleaned up, could only be established by the wife. Mr. Okendo, when he talks about that, he's really saying what his wife told him. And that's clear when actually he says in the record...
If his wife tells him, honey, there's water on the floor and I'm having to clean it up every day, that's not knowledge?
Well, that's knowledge of water being on the floor. It doesn't really tell you where the water came from. For example, and he says this on the record in his deposition transcript, for a long time they just thought it was the kids that were spilling water when they were getting water from the sink or not being careful. So there's a real question of fact as to when or at what point Mr. Okendo or his wife should have known that this was something related to a covered loss. This is not the type of situation where, unfortunately, it wasn't fleshed on the record whether or not he knew this at what point in the 3 years. We just have the general reference to the fact that water had been observed on the floor over the past 3 years, but it's not really exactly clear when. It starts to hint in that direction, and perhaps a jury would find the way that the trial court did, but precisely our argument is the jury should be allowed to review this evidence, the jury should be allowed to evaluate his testimony, evaluate his explanations, and then decide when, in fact, that water was observed, and whether it was actually water that came from one of the children, whether we know, or whether it was water that came from somewhere else.
Well, what's the explanation for not knowing that this was going on for 3 years plus?
Well, most generally, I would say that Mr. Okendo is a retired truck driver, and he not having any kind of plumbing knowledge, only having the type of knowledge that we might have as homeowners, having to relate, looking at all of the testimony, having to relate odor, having to relate yellowing baseboards, when there's also record testimony that the wife was spraying Clorox on the baseboards, having to make a connection between water being found randomly on the floor in different rooms, I think that's too tenuous. I think that's not, first of all, if that is enough, I think that's something the jury should be deciding. The biggest problem I have with that testimony is there's no real fix on when he actually knew that. The record is completely devoid as to when these things were actually detected. We just know that throughout the 3 years, and he observed things, or his wife observed things and then told him about it. And the problem I have with that is there's just not enough specificity. We don't know enough about when, where, how, and what the circumstances were. We just know that this gentleman now has the benefit of
3
having...
years of having to put water in the toilet to get it to flush sounds awfully specific to me, frankly.
Well, that's just it. I think if you call your insurance carrier and say, I've got to add water to my toilet to make it flush, they would say, call a plumber. They wouldn't say, we're going to come out and inspect it. And I'm speculating when I say that, Your Honor. I don't have anything in the record on that. But I think when you're adding, you could easily conclude that that's just, my toilet's not getting enough water. Maybe the valve is turned down. The number of reasons to explain that are numerous. I think really the most important problem with that is that we don't have any real specificity except for the fact that he had to do it every other day or so. I concede that, but I don't think there's enough there to tie it to a particular plumbing leak. Even to this day, I don't know if that's something that the plumber would tell you, yeah, sure, when you have a drain line problem or when you have a problem with something else that's going to cause your toilet to flush slower. I personally don't know that. I don't know what a plumber would say. I think this is a case where, although everything is hinting in that direction, we're lacking that last bit of evidence. We're lacking either some firsthand actual observations from the wife, or we're lacking something from a plumber saying these problems are causally related. This is what the issue is, and this is what caused the humidity. This is what caused the moisture. now you might have something. At this point, we're all really just guessing. We're making inferences, and wherever you can make the inference that this water was related to the particular loss, I think, at summary judgment at least, the insured is entitled to the inference, no matter how slight, that maybe it wasn't related to the loss. And so, in fact, maybe he was just seeing water that was related to something that the kids did in serving themselves a glass of water. Returning to the unpled defense, the appellee has raised the fact that it wasn't argued below, and thus it was not preserved. We contend that the error was a fundamental error. We contend that because the error in not raising the affirmative defense, because the lack of an affirmative defense being pled on that issue wasn't raised in opposition to the motion for summary judgment, we contend that essentially this was an error which goes to the merits of the case. We are now dealing or contending with a judgment that is predicated upon an affirmative defense that was never pled. The issues that raises are numerous. First of all, we have a, I'm sorry? We have a judgment that's predicated upon an affirmative defense that was never pled. We have a plaintiff that testified at his deposition, not knowing that that would ever be an issue. And then we have the summary judgment, which essentially seeks to capitalize on that particular fact.
Well, it seems like, reading the transcript of the hearing on the motion for summary judgment, it was really just about whether or not he should have known about this, and these issues just were not presented to the trial court for decision.
I attended the oral argument, and I can tell you I essentially did not argue very vehemently on those particular issues, and they were scarcely brought up in the opposition, which is why...
So how is it preserved for us to rule on it now?
It's preserved because it's a fundamental error, and in the DiCastillo case, which is cited by the Stevens case in our brief, the DiCastillo case, I think it's analogous to this situation, because in that case, the court essentially said in that case, there was a wrongful death case that where the court essentially applied a statute incorrectly. And because that was something that went to the heart of the case, to the merits of the case, the court found that even though that was not raised at the lower level, that it was still an issue that was preserved for review. It was a fundamental error, and it could be essentially the basis for reversing the trial court in that case, and that's what they did. In this case, we have the Rule 1.10, which essentially says an affirmative defense has to be pled, otherwise it's waived. So what we have here is really, the contention is, first you have an affirmative defense that is not brought up by the insurance carrier. And then later down the road, you have the insurance carrier trying to allege that affirmative defense in a motion for summary judgment, and an error on plaintiff's counsel and not bringing that up as a failure. So we have two mistakes that go to the heart of the case, and then this judge is actually very, very careful, read everything before. So, I mean, no disrespect to the trial court, but quite frankly, I think the trial court also missed the fact that it wasn't pled as an affirmative defense. And so this is I think,
Well,
the
isn't she
quintessential.
supposed to rule on the issues that the parties raise? I mean, she doesn't have to go out and look for issues, does she?
She doesn't, but I think as the trial judge, I think one of your obligations is to review the pleadings and make sure everything's in order and essentially protect against fundamental error. That's one of the reasons, or one of the purposes that a trial judge serves. And in this particular case, make no mistake, this is the quintessential definition of fundamental error. Now, I have considered an alternate path for preserving this argument. Essentially, we have two competing policies here. We have, on the one hand, the policy which says a final judgment predicated on a waived defense should be reversed, and it's competing with the appellee's argument, which is advancing the idea or the doctrine of waiver. I think by ruling in favor of the insured today, this court can serve the more important policy. I would ask the court to balance these two policies and weigh more heavily in favor of keeping judgments clean, keeping judgments from being predicated on unpled defenses, as it is here, It's a more syllogistic and it's a more streamlined approach to deciding that particular issue, if this is not a fundamental error. I want to revisit the particular ambiguity in the policy language. Our first argument is the plain reading of the language is more than enough to reach the decision that I'm urging the court to take. Specifically, if we go to page 15 of the brief, the unnumbered paragraph after 29E, and in case you're relying on the record itself, this is volume 1, page 93. If any of these excluded perils, and I've inserted the word excluded perils, but the pronoun these is referring to the excluded perils. This unnumbered paragraph that I've quoted comes immediately after section 1, paragraph 2, 9 sub E. This paragraph indicates if any of these, and we contend these as excluded perils, cause water damage not otherwise excluded, and that otherwise excluded is referring to the language that I have on the next page of the brief, which is the exclusions for surface, tidal water, flood water, water that comes out of sewers, that sort of thing. So here what we have is an exclusion, and then you have this paragraph which saves a loss from an exclusion by saying you also have to meet this third peril. That is the reading that I'm urging the court to take. If there is another reading, if there's any other reading, then that would render it ambiguous, and again, would bring us back to, I would contend, being entitled to the more favorable interpretation.
You're getting into your rebuttal time, Mr. Trivedi. You've got 5 minutes left. You can use them as you will.
I was just about to end if there's no further questions.
All right.
If it may please the court, my name is Hala Sandridge, and I represent United Property and Casualty Insurance Company. I would first like to address the testimony and the deposition of Mr. Okendo. I think it is absolutely 100% clear that Mr. Okendo admitted during his deposition that for 3 years he knew about the leaks and saw the damage and decided to wait to report it because he said he didn't know what the cause was. And so, Judge Morris, I think you hit the nail on the head because the policy doesn't say you get to wait until you know what the cause is. The issue is, do you know there is water that's leaking or seepage, and do you see the damage? And here's his testimony. And this is at the record, all out of volume 3. This is page 424. The question is, so, a little bit of water will come out at a time. Answer, it's not a river of water. It's not a river of water. The water comes out little by little, so then it wets the wall. And if you're not careful, sometimes it also comes out at the bottom. Otherwise, we wouldn't be here. Okay, this is the question. So how long has that been going on? Answer, it's been happening for about 3.5, 4, could be 3 years. This is Mr. Okendo saying that he himself saw this water leaking for 3 years. I've got 6 places of this. I honestly can go through every one of them. I'm going to just give you the record sites, but it is over and over and over again that the trial attorney made sure he cornered him on this issue of knowledge of the leaking, and this was not just his wife's knowledge, this was his own personal knowledge. Record 427, record 434, record 446, record 449, and record 452. And here's what's important at 452. The question I think, Judge Wallace, you asked, and maybe, I'm sorry, Judge Morris, maybe you asked it, one of you did, about whether or not, why he gave an explanation, would he wait? That question was asked. Page 452, okay, why would you wait 3 years to report a claim? Answer, I wanted to be sure if it was a problem with the water coming out of the walls, or sometimes the hot and cold water have problems with leaking, or if it was something more serious. That's why I let it go this long. So you waited 3 years and you never called a plumber? No, I never called a plumber. He knowingly decided not to call even though he knew the water was leaking. He saw the water going up the wall, the baseboards were yellowing, the damage was visible. So there is a trial judge that's faced with all of this overwhelming testimony. It's not an issue of deciding credibility or having conflicting evidence. There it is, black and white, he admits over and over again. So what do? They submit an affidavit that attempts to contradict this testimony. Now, it could be explained away that this affidavit was meant to say, well, I didn't know what the cause was. But then, in a subsequent paragraph, it attempts to try and say that he really didn't know for 3 years what was going on, and instead, what he was really talking about is what he learned in hindsight. And that just can't be reconciled with this testimony in his deposition. You are all familiar with the well-known principle of law that a deponent cannot contradict his deposition testimony with an affidavit in order to avoid summary judgment. And this trial judge applied that well-known principle and said, this affidavit is not going to create a genuine issue of dispute. And so I believe that on this record, we have overwhelming evidence to support the summary judgment. With respect to these newly raised arguments regarding coverage, I have 3 comments. Number 1, they weren't preserved. None of them were brought to the attention of the trial court judge, and what the plaintiffs are asking this court to do is to reverse this trial judge, finding that he committed error when these specific arguments were never brought to his attention. Number 2, it does not rise to the level of fundamental error. This in no way fits within the format of the Supreme Court's definition of fundamental error. There is no denial of due process. They were absolutely on notice. We denied their allegation that they gave timely notice, and this entire summary judgment was an argument about whether or not there was timely notice. So under the facts of this case and Supreme Court law on fundamental error, none of these arguments can rise to that level. If there are no further questions, I will be seated.
All right, thank you, Ms. Sandridge.
Thank you.
All right, rebuttal.
I just lost my pager on it. Assuming for argument's sake that this affidavit filed in opposition to the motion for summary judgment is baldly repudiating pre-deposition testimony, there's still, it's not entirely in bald contradiction to his deposition testimony. If anything, it's only in bold contradiction to 1 or 2 points, specifically the areas in the record where Mr. Okendo says that he's seen water at different times. I think what's really important here is we don't have any connection between what damage that caused and what damage, if any, had been caused before that. There is still coverage under this policy. There should still be coverage for any new damages. There should be coverage for damages that weren't attributable to any kind of a delay. There should be coverage for anything that essentially wasn't established as particularly excluded by what Mr. Okendo noticed at some point. And I still urge the court to consider the issue that it really is questionable how much he actually knew himself. He's the only insured. His wife is not an insured. And the reason that's important is the policy language specifically says if any of the insureds know of these items, then the exclusion applies. But they have to know about moisture. They have to know about the water. And he doesn't personally know of these things, save for the fact that he's been told by his wife about specific items, which I would contend is not admissible for our consideration. And more importantly, I think we're still entitled to the inference that this water could have been water that was just spilled by the children. We need more evidence on that issue. And then let's let a jury decide where that water came from, whether that water was it the kids spilling it on the floor, or was it something else? And no further questions, I choose to stand on my brief.
All right, thank you both.
Thank you.
That will conclude the arguments today, and we will be adjourned.